Why won't some divorces settle? Some divorces won't settle because people are not emotionally ready for that to happen yet. And of all the financial questions that are so important in a divorce mediation, child-related questions that are so important, frankly, the single most important question is everybody emotionally ready to get this done and to walk away from the marriage? And it's just not the case that everyone is. And I can tell you from 3 decades of experience that if someone is not ready, it will not happen that day. They're not emotionally ready. They're not going to be making decisions to end a marriage that they're not ready to walk away from. So that's probably the single most important reason that I see cases not settling. Someone isn't quite there. They'll get there, but they may not be there that particular day. Other reasons that cases don't settle are primarily that pieces of financial information aren't ready yet. Maybe a pension hasn't been valued. Maybe there's a problem with a sole proprietor's business valuation. It's not finished yet, or there's something wrong with it, or the other party needs to hire an expert to counter it. You never quite know, but sometimes there's just data that can't be had timely enough for the mediation, and that's okay. It doesn't all have to be done in a single day. It can happen over some time and be just as effective. Some cases, however, don't settle because of the personalities that are involved. We've talked briefly about the competitive aggressor in a different little clip. That competitive aggressor personality can often be paired with what's called the cooperator. And in that scenario, the cooperator may not be ready to take the financial hit that's going to come almost 100% of the time. When you look at the research on how those two personalities do with each other, the competitive aggressor comes away with the better financial result, something like 98% of the time. And that cooperator may not be ready to swallow that day. Or sometimes you can have two competitive aggressors in the same marriage. It does happen. Luckily, it's not often because it is not pretty and it's not easy. And when that happens, it's a fight to the death, typically about winning and what winning means to one or the other of them versus what is a reasonable resolution based on what a court might do. So the personalities matter. Should you ever leave a divorce mediation before the mediator says you should? The answer is no. You should never leave a mediation until the mediator has green-lighted you. And the reason is quite simple. You're in one room with your lawyer and your spouse is in the other room with their lawyer, and only the mediator is going back and forth between the two rooms. And only the mediator is hearing both sides of this story and looking at all sets of documents in the various rooms. So only this mediator knows how close you are to being able to get a resolution, or how close you may be for the mediator to call it as unresolvable, which luckily doesn't happen very often. So letting the mediator guide on when a termination happens, not necessarily a break. You might want a break. You might want to come back another day. Your spouse might need a break. I'm not talking about when you break, but when you terminate the process, you really need to leave that up to the mediator. What do you recommend that divorce lawyers tell their clients when there has not been a settlement at mediation? I think it's really important to give hope at the conclusion of an unsuccessful mediation, that you are going to continue to work on settlement as you work towards litigation, getting ready for a trial. I think you can also tell clients in the average mediation that you can go back to mediation on a different day at a different time once some legal maneuvering has happened. And often that is a highly successful thing to do. Take a few legal steps that might change the landscape a little bit in a case on the legal front, and then go back to the mediator and let that mediator try again. A large percentage of those cases will settle.
Suzanne, as a follow-up to that, how often do you see a settlement framework, a structure that gets changed, say in the afternoon of a settlement, and one party just needs some time to sleep on it, chew on it, percolate, whatever you want to call it? One of my favorite lawyers refers to it as sharpening the pencils. Is that how often do you see cases settled, but parties just need a little bit of time to readjust to a potential new framework?
That process of needing to adjust a little bit after a theoretical settlement has been reached in mediation is really not very common. Typically, by the time we have gotten to that theoretical settlement, everybody really wants it inked and signed and filed. However, there are those cases where people have worked really hard, maybe it's late in the evening, and they just want to sleep on it before they sign. It is very important to respect that. It makes lawyers and mediators nervous because we're worried someone's going to sleep on it and then change their mind, and we've worked hard to get to a resolution. But you never want anyone to feel like they were forced into a settlement at a mediation. It is very important that it come freely from them. And so letting them have that time, while it might make the professionals uncomfortable, is an important thing to allow.